Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. Looking for ways to keep calm and serve your clients? With the state of immigration law today, I bet I know the answer. Well, on September 30th, the podcast friends at e-Immigration are hosting a live webinar with performance psychology expert Nikola Milankovic that's all about stress management. It's not just your typical just breathe session. You'll learn practical tools rooted in psychology and high-performance coaching, how to manage self-talk, control your attention, and create a culture that supports resilience. Go to get.eimmigration.com/events to save your spot, or click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. We've got some good news for the rule of law and immigrant children this week. Won't somebody please think of the children? In a decision granting a preliminary injunction, a district court judge rejected the government's argument that they were trying to reunify Guatemalan children with their parents. That argument, quote, crumbled like a house of cards, end quote. This is LGML v. Noam. As you guys may have seen, over Labor Day weekend, the government tried to round up and expel dozens of Guatemalan children in the middle of the night. What you may not know is that lawyers and advocates from ProBar in South Texas sprung into action. They advocated for the children from being put on buses and planes, communicated with shelters and contacted litigators to try to put a stop to what they thought was unlawful conduct, and moved to enforce a middle-of-the-night TRO that was granted by an emergency D.C. judge. Fortunately, their hard work and quick thinking was successful, and with the help of litigators at NILC and a national network of children's advocates, they obtained a preliminary injunction. The struggle continues, but the children are safe for now. ProBar and the American Bar Association doing very important work to protect the most vulnerable. I encourage you to all donate to ProBar, which has been on the border fighting these fights since 1989. If you want to donate, just put the words Immigration Review in the comments section of your donation. You can find ProBar on social media at ABA ProBar or donate at ambar.org/donate ProBar. More about their work in the show notes. Thank you, ProBar, for thinking of the children. Also this week, late Friday, the Sept Circuit held that F1 Indians subjected to expedited removal at the border and then expeditiously removed cannot sue for their removal under the APA. That's Dubé v. DHS. And finally, I've got an interesting immigration-type criminal case to review from the Ninth Circuit if the BIA would just let up. For 1 week. Just a little. My God. But this week is not that week, as you will see. Man, that's a pretty cool thing ProBar did, right? Go ProBar. Go ABA. Rock on. I'm glad they're on my side. Here are your cases. First up is Lopez-Gomez v. Bondi, published by the First Circuit on September 22nd, 2025. This case is about late-filed BIA briefs. Not recommended, but it happens. And you know what? Miss Lopez-Gomez won. She filed an EOIR 26 notice of appeal past the 30-day deadline after the immigration judge denied her asylum application. And wouldn't you know it? The BIA set a briefing schedule anyway, likely years later. Ms. Lopez-Gomez then filed her brief on time through the ECAS system. Quote, inadvertently, however, she made a technological error by filing the brief with the immigration court instead of the BIA. And can I just say how easy a mistake that is to make? How I've made it myself, and how it is such an unnecessarily user-unfriendly feature? BIA? There is no cause for it. And by the way, the brief goes to the same EOIR timely. You're just accidentally selecting the immigration court instead of the BIA. Unlike me, however, Ms. Lopez-Gomez didn't have a heart attack and realized this absurd issue right away, and instead only figured it out when the immigration court rejected the brief 3 weeks later. Ms. Lopez-Gomez then filed the brief with the BIA. She refiled it, which the BIA rejected as untimely. They wanted a motion to consider the late-filed brief. Counsel submitted said motion, and the BIA denied it without meaningful explanation because, of course. Then the BIA dismissed the appeal for failure to file a brief. And come on, BIA. Have you seen how easy a mistake this is to make in the system? Have you thought about adding a feature to make it such that well-intentioned practitioners would never be able to file an appeal brief with the immigration court by mistake, or that at a minimum it would be far more obvious which of the two processes a filer is in? Anyway, the First Circuit was not moved by the BIA's decision, or lack thereof. Quote, if the BIA's explanation is too thin to allow us to evaluate the claims of error, we may find an abuse of discretion and remand to the BIA for further explanation. End quote. Too thin, said the court. No explanation at all why the BIA's discretion wasn't warranted here in this, such a sympathetic case. Just generic language from the BIA denying everything and deporting an individual. Quote, the BIA's lack of explanation is particularly troubling because Ms. Lopez-Gomez's motion seems to present at least a tolerable basis for the BIA to favorably exercise its discretion, end quote. And when everything was corrected, quote, the resulting delay was not extraordinary. Rather, it was well within the period of extensions that the regulations authorized the BIA to grant in the ordinary course of proceedings, end quote. That's 8 CFR section 1003.3C1. So, the First Circuit sent it back. Give her a chance, BIA. The podcast urges you. And congratulations, Tadzi Pomalu and Jeffrey B. Rubin for petitioner. And that is Lopez-Gomez v. Bondi. Hope you like losses for non-citizens, because it's all downhill from there. Moving on to Zapet-Alvarado v. Bondi, published by the First Circuit on September 22, 2025. This case is about asylum and related relief. Ms. Zapet and her minor son are from Guatemala and applied for asylum in immigration court just over 2 years after entering the United States. Her claim relates to a land conflict. Her home village of Loma Linda is in an area subject to land conflicts between the Tajumulco village and another community. For roughly 4 years before Ms. Zapet arrived in the United States, unidentified hooded men approached her and her husband to obtain their support in the ongoing conflict. The men did not specify the nature of the support that they sought. However, they threatened to kidnap Ms. Zapet's children if support was not forthcoming. The threats continued until 2021, when Ms. Zapet left for the United States. An immigration judge denied the asylum claim as untimely, and did not believe that Ms. Zapet's unawareness of U.S. immigration law and the 1-year filing deadline was an extraordinary circumstance that would excuse her from the 1-year filing deadline. Somewhat arbitrary and harsh rule, yes. Extraordinary to the IJ and the BIA? No. The IJ then found that Ms. Zapet didn't suffer past persecution and didn't have a well-founded fear of future persecution or torture, and denied withholding of removal and Convention Against Torture Protection. The BIA affirmed. In part, for example, as well, the IJ reasoned, quote, because Ms. Zapet had remained safely in Guatemala for 4 years while the threats persisted, it was reasonable to believe that she could relocate safely within the country, end quote. The First Circuit upheld the agency. On asylum, in fact, it held that it lacked jurisdiction to review whether an extension of the 1-year deadline is warranted. That's because the statute tethers that to the, quote, satisfaction of the Attorney General, end quote, that extraordinary circumstances or a material change occurred to excuse the deadline. And while those are standards, there is literally a jurisdiction stripping provision about the extraordinary circumstances exception, which is at issue in this case, and the First Circuit ruled on its applicability many years ago. Ms. Zapet argued that Grau-Lasprilla and Wilkinson from the Supreme Court changed things, that just like there, the extraordinary circumstances inquiry requires a court to review the applicability of settled facts to a legal standard, so the jurisdiction savings clause permits review, notwithstanding the very specific statute limiting jurisdiction. It's a good argument, but the First Circuit was not swayed. The argument here is that the cumulative facts meet the standard, but that's too factual to the First Circuit to save review with a specific jurisdiction stripping statute, and again, it's all to the satisfaction of the Attorney General, which really could mean anything to the court. The First Circuit believes that this no jurisdiction holding aligns with the Third and 11th Circuit, post-Wilkinson. Nor does Loper-Bright save the challenge. Dead in the water. Rough stuff. On to withholding of removal then. The First Circuit affirmed denial. Here we have mainly quite scary threats, and indeed, quote, a past persecution claim may be based on threats, end quote. But they have to be so menacing to cause actual suffering or harm to the panel, or I guess be sufficiently concrete. The First Circuit doesn't say that last part, and actual violence does make a past persecution claim more likely, explains the court. Not enough shown here. Miss Zapet was apparently vague about what actually happened to her, the timeline, and what the hooded men threatening her involved in her inter-community land dispute wanted anyway. And although they threatened to kidnap her family, it never happened. Quote, hollow threats, end quote, to the First Circuit, without any showing that it caused Miss Zapet actual harm or pain. As to future persecution, well, the evidence of generalized danger in Guatemala does not cut it to the First Circuit. Plus, that relocation finding seemed reasonable to the court. Finally, then on CAT, same problem with those threats, and generalized violence does not show government consent or acquiescence, as the Convention Against Torture requires, explains the First Circuit. So it denied. And that is Zapet-Alvarado v. Bondi. Do you like 5 BIA decisions in 1 week? I know I do. The first is Matter of McDonald, published by the BIA. The BIA's blitzkrieg continues, this one about discretion, and made precedential by the Attorney General when, formally, not precedential. Man, I would like to know who is really identifying these cases for the Attorney General and how this is all working. You know they've got a procedure. There's got to be someone at the BIA who's about to not be at the BIA who wants to email or call me soon. 305-444-0060. Mr. McDonald, not McDowell, is a lawful permanent resident from Canada and was granted cancellation of removal for lawful permanent residence. Assuming you've got the years and don't have an aggravated felony, all you've got to do is show that you're not a bad enough person. Too bad, reasoned the BIA. Cancellation revoked. He's been an LPR since 1991 when he was 24 years old. Has lots of positive equities, it seems, including a daughter in the United States, employment history, and other things. But he also has convictions, and you'll be hard-pressed to find a recent BIA decision finding that the equities outweigh a conviction. Any conviction, really, it seems, of late. Here it's 2 convictions under New York Penal Law Section 260.101, a Class A misdemeanor that covers a broad range of conduct and is not limited to any sexual abuse or contact. Here, the IJ based its ruling on part, I guess, on the fact that the IJ believed that no sexual conduct with the victim occurred. And that was based in part on the fact that the IJ believed that the conviction is not a sexual offense-type crime. That was error, though, explains the BIA, because it could be a sexual-type crime. And I can only imagine, far more importantly, that the charging document from 2021 did mention sexual conduct. Never proven in a court of law, it seems, and never admitted to, I can only imagine, but that is not overly important to the BIA on discretion. There is, after all, a victim statement that has some very bad stuff in it and involved a 14-year-old. Quote, We acknowledge the respondent's testimony that the victim was either dreaming or was coached in making her statement, and that his claim that this relationship with the victim was platonic, end quote. And I imagine that the BIA recognizes that none of these allegations were ever proven or admitted to in criminal court. But it is apparently uncontested at a minimum that Mr. McDonald did travel with the victim to assist her in getting drugs. I'll tell you what, though. If the Attorney General believes it's important to remove individuals based off allegations of a sexual nature not proven in court made by child victims against adult men, I do wonder what the Attorney General thinks about the allegations that she has 1,000% seen against the current president of, you know what? Not going to go there. Not going to do it. Don't want to get canceled. All of it outweighs what appears to be significant equities and important ties to America. Mentioning some things about credibility in dicta, the BIA ordered Mr. McDonald removed to Canada. And that is matter of McDonald. Moving on to matter of JA published by the BIA. This case is about Convention Against Torture Protection. The Attorney General made it precedential too. Mr. J.A. is from Uzbekistan and was granted deferral of removal under the Convention Against Torture. The BIA and the Attorney General just hate it. And indeed, in a decision that the AG decided to make precedential, quote, the BIA denied the respondent's motion to accept his untimely filed brief. Our decision, therefore, refers to the arguments contained in the respondent's notice of appeal, end quote. As such, not much counter-argument being made and not any defense of the IJ's CAT deferral grant for the BIA to have to really get around. Quote, the respondent testified that Uzbek government officials orchestrated his arrest in Russia based on false allegations that he joined an online group affiliated with a terrorist organization. The respondent was detained in Russia for a year while Uzbek officials tried to have him extradited. The respondent alleged that he later traveled to Turkey, where 6 men with Uzbek accents attacked and tried to kidnap him. The respondent was arrested in the United States in April 2024 pursuant to an Interpol Red Notice and subsequently applied for asylum and related protection. End quote. And IJ did not believe Mr. J.A. and deemed him a security risk, but for reasons largely unexplained by the BIA, granted deferral of removal under the CAT. I am certain the IJ explained him or herself at length with this one, but those reasons are not extensively relayed in this previously non-precedential decision. The BIA affirmed the adverse credibility finding, of course, quote, material inconsistencies within the respondent's testimony as well as significant discrepancies and omissions between his testimony and the other evidence of record, end quote. Something to note, though, the BIA appears to be holding that non-citizens can qualify for asylum and withholding of removal under the INA, even if they are deemed not credible. Quote, in the absence of credible testimony, the respondent has not provided sufficient reliable and persuasive evidence to rehabilitate his non-credible testimony and meet his burden of proof for asylum or withholding of removal, end quote. But I guess he could have. Remember it. The BIA then explained that the IJ properly relied on an FBI memo to deem Mr. J.A. a national security risk. Not only did Mr. J.A. not provide sufficient grounds to suppress that document, such as it being a product of duress or coercion, but it was due significant weight, even if not properly authenticated. Without so much as mentioning the regulations requiring authentication of documents, the BIA states that, quote, the fact that a document is not formally authenticated does not mandate that the evidence be rejected or suppressed. Instead, in immigration proceedings, the sole test for admission of evidence is whether the evidence is probative and its admission is fundamentally fair, end quote. Turning then to the grant of CAT deferral, it requires an IJ to answer 2 questions. Quote, 1. What is likely to happen to the respondent if removed? And 2. Does what is likely to happen amount to the legal definition of torture? End quote. The first question is factual, and the second question is legal, explains the BIA. Now, the IJ reasoned that the immigration judge reasoned that the respondent will more likely than not be detained immediately upon his return to Uzbekistan and subjected to torture by the Uzbek government officials. But the BIA does not like that. To the BIA, the IJ, quote, erroneously conflates the respondent's risk of arrest with his risk of torture, end quote. Even if he'll be arrested, the BIA sees an insufficient record on torture. The European Court of Human Rights report, or ECHR, relied on by the IJ here apparently is general in nature and does not apply the same standard that an immigration judge must apply when analyzing a CAT claim. Need an ECHR report to mention the respondent, BIA? Maybe. But my God, it seems like Mr. J.A. has that. It seems like he literally obtained an ECHR report pertaining to him specifically, somehow. And yet still not sufficient to the BIA to affirm a CAT grant. Quote, the ECHR document finds the existence of substantial grounds for believing that the applicant faces a real risk of ill treatment in his country, end quote. But that's not necessarily torture, explains the BIA. Can I just stop to note the half dozen or so CAT cases of late faulting CAT applicants for not producing evidence specific to them, and now this decision faulting the exceptionally difficult to obtain evidence specific to Mr. J.A. because it doesn't use the word torture? Beyond that, the BIA doesn't believe the evidence sufficient, as there were simply a, quote, relatively small number of anecdotal incidents of mistreatment or death, end quote, presumably in Uzbek prisons. Isolated, explains the BIA. Relying on limited examples by the Department of State, examples that Secretary of State Rubio has already said will be further limited in years to come, the BIA did not see sufficient evidence. And finally, explained the BIA, Mr. J.A. didn't show how the Uzbek government officials would have a, quote, specific intent to torture him, end quote. That is a standard directly at odds with the one explained by the First Circuit last week in Florimond v. Bondi, so I imagine this portion of the decision is bad law in the First Circuit. To the BIA, though, quote, the record does not establish that any potential harm the respondent may face as a detainee in Uzbekistan is the result of a specific intent to cause pain or suffering, end quote, so Mr. J.A. loses. But again, probably not in the First Circuit. Quote, even assuming that the respondent will be detained upon removal to Uzbekistan, the immigration judge's decision does not provide a sufficient basis for concluding that the Uzbek government will more likely than not be motivated to purposely inflict torture upon him, end quote. Again, broken record, seems like bad law in the First Circuit, and maybe a misreading of the regulations, but what do I know? No mention of possible torture by low-ranking officers either. Ritsang Kim. Citing, as always, the matter of JFF, the BIA took away CAT protection and set Mr. J.A. on a course to Uzbekistan. And that is matter of J.A. Next up, matter of Frias Ulloa, published by the BIA. One of those weeks at the BIA. They all are these days. It is another non-precedential decision made precedential by the Attorney General, this one about controlled substances and the categorical approach. Mr. Frias Ulloa appears to be a lawful permanent resident and was convicted of violating Section 2C:35-5B4 of the New Jersey statutes annotated. That's possession with the intent to distribute a controlled, dangerous substance. New Jersey criminalizes doing that with a lot more controlled substances than do the feds in the Controlled Substance Act. So if the statute isn't divisible, Mr. Frias Ulloa likely isn't removable. But it is divisible, explains the BIA. Comes down to penalties. Different penalties depending on the controlled substance at issue. Now to me, the IJ performed the correct analysis. Yes, you get different penalties based on the type of drug possessed pursuant to subsection B of the statute, but even that is based on different categories. Here, for example, Mr. Frias Ulloa was penalized pursuant to subsection B4, which has many controlled substances listed therein. And that subsection, that is B4, isn't further divisible, right? Because all the drugs in it have the same penalty? And I guess there are overbroad drugs in subsection B4? Always hard to figure out in these supposed to be unpublished BIA decisions. But anyway, the IJ didn't believe B4 further divisible, meaning that the IJ believed that the IJ could not go and further see what substance within B4 Mr. Frias Ulloa possessed. Makes sense to me. Not to the BIA, because it already held in matter of Laguerre that a similar New Jersey statute was divisible vis-a-vis the controlled substance possessed. That's episode 91. BIA does not explain why the IJ was wrong or why Laguerre's reasoning undermines the IJ, just that they like Laguerre. Additionally, the BIA relies on a, quote, unpublished but extensive, end quote, Third Circuit opinion, finding subsection B1 divisible vis-a-vis the controlled substance possessed. So that's not subsection B4, but the Third Circuit did disagree with the IJ's logic here that, quote, because the penalty subsection groups drugs without listing the drugs in the alternative or providing for different penalties, it's not further divisible by substance, end quote. The BIA finds this unpublished Third Circuit decision's reasoning persuasive, but I would like to know what that reasoning is. I've yet to hear reasoning. So even though the actual penalty portion is overbroad, it seems, the BIA is using the fact that different penalty categories exist in the first place to hold that the modified categorical approach completely applies and they can look to the substance possessed. Again, even though the actual penalty provision at issue in this case itself appears overbroad and not further divisible. But having gotten their foot in the door and then kicked it wide open, based largely on logic from an unpublished Third Circuit decision, the BIA saw that fentanyl was possessed, which is also on the federal controlled substance list, and so makes Mr. Frias Ulloa removable. Now, Mr. Frias Ulloa did have two other arguments. It was DHS's burden after all, and he argued that the record was unclear about what he actually possessed. Although the documents mentioned fentanyl, it actually seems that the conviction documents don't mention subsection B4. Weird then how that whole modified categorical analysis that I just discussed is possible, but whatever. And in any event here, the BIA was not convinced. It had to be subsection B4 in order for Mr. Frias Ulloa to have a second-degree offense, explains the BIA. Nor does it matter that DHS itself alleged that it was heroin in the I-213 and that is completely wrong. Nor does it matter to the BIA that fentanyl itself is further divisible into salt and isomer chemical formulations, which are overbroad vis-a-vis the federal controlled substance definition of fentanyl. That's a big deal argument. And astonishingly, the BIA does not cite the matter of Felix Figueroa to reject it. Why not, BIA? Feeling a little uncomfortable about Felix Figueroa? To be honest with you, I don't quite understand the BIA's logic. Here it is. Maybe you understand it. Quote, because the respondent's statute is divisible by substance, we need only determine what substance his conviction involves. And the fact that New Jersey may control other substances is irrelevant, no matter whether the differences between those substances and fentanyl are obvious or apparent only under a high-powered microscope. End quote. Unsure what all that means or why the BIA says it, as the BIA also seems to rely on the fact that New Jersey criminalizes possession of fentanyl and other, quote, illicit fentanyls, end quote, and Mr. Frias Ulloa was only convicted of fentanyl and not the other illicit fentanyls, which is listed in the CSA, that is fentanyl. If true, that would be the dispositive reasoning to reject Mr. Frias Ulloa's argument, at least to me. Not so much reasoning there either, though. I don't know, man. Seems to be what happens when you make a non-precedential decision about the categorical approach precedential. And Mr. Frias Ulloa was ordered removed. And that is matter of Frias Ulloa.
Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month.
Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure,
You can pause directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez and Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez and Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez and Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez and Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. Moving on to matter of Cotrufo, published by the BIA. The Attorney General has also decided to make another bond decision precedential when previously it was not. An immigration judge granted a $6,500 bond to someone who may or may not be an LPR. The BIA doesn't say, but I would think that would be an important factor in a bond decision. The BIA does not like the bond grant, and neither does the Attorney General. The BIA reviews de novo whether a non-citizen is a danger. And remember, DOJ has made up rules whereby non-citizens have the burden in bond proceedings. Now, the non-citizen here was recently convicted of 1 felony count of unlawful sexual intercourse with a minor in violation of Section 261.5c of the Cal Penal Code, and 2 counts of oral copulation of a person under 18 years of age in violation of Section 287b1 of the Cal Penal Code, 1 being a felony and 1 a misdemeanor. There's a 3-year age differential required of the first statute and no age differential at all required of the second, just that the other person is under 18 years old. Mr. Cotrufo was 18 years old at the time and engaged in sexual intercourse with someone who told him she was 16 but turned out to be 14. Mr. Cotrufo completed his sentences, and the people in charge of creating risk assessments in Ohio stated that Mr. Cotrufo is a low risk. But another report seems to opine that he's an average risk of reoffending. Then again, the probation officer noted that Mr. Cotrufo acted in a manipulative manner with the victim and didn't appear remorseful. Immigration proceedings must be fundamentally fair. Nevertheless, explains the BIA, quote, the IJ's decision to limit his review to only the undisputed facts and objective data in the probation officer's report on the grounds that the declarants were not available for cross-examination was unreasonable, end quote. Maybe not in the Ninth Circuit, though. Check the podcast page. IJs have wide range in bond proceedings, says the BIA, and they can consider probation officer reports even if it's single, double, or triple hearsay, and the officer doesn't testify. Explains the BIA. But also check the First Circuit on the podcast page. Definitely some law to undermine all this. But return to the BIA, Mr. Cotrufo has the burden, and he did have the opportunity to present contradictory evidence. Although I do seem to recall a recent BIA decision holding that IJs can't go behind the facts of conviction, but I guess they can go behind a probation officer's report, according to this decision, but only if sufficient facts exist. Plus, explains the BIA, Mr. Cotrufo himself relies on portions of the report. In the end, and despite all of it, it does seem to me at least that the BIA's decision is coming down to their statement at the end that, quote, he subsequently learned that she was 14 years old, and yet he continued to engage in unlawful sexual relations with her, end quote. And he also knew that she had already suffered sexual abuse. This, even though Mr. Cotrufo was not required to register as a sex offender by the state. To the extent he's otherwise a good person, explains the BIA, quote, family and community ties generally do not mitigate a non-citizen's dangerousness, end quote. So, Mr. Cotrufo remains in private prison.
When do we think that the Attorney General will decide to make a non-precedential BIA decision precedential that moves the law in a direction favorable to non-citizens? Any bets? Whoever emails me with the closest date gets some stickers. No one gets anything if it never happens, and I will retract the stickers that I have sent to some of you as well. And that is matter of Catrufo. My weekly journey with the BIA concludes with matter of LALT, published by the BIA. Not gonna lie, guys, if the BIA is going to make a practice of publishing 5 cases or something close every week, the podcast's gonna have to start skimming them. There's a lot. Isn't it just incredible, too? What is this, like 50 decisions in 7 months? What an incredible difference an administration makes. This case is about asylum. Mr. LALT is from El Salvador and testified that he is not a gang member, but that police there believed he was in 2018. 2-hour beating, which is just horrific if you think about it, and threats to kill him by the police. Similar thing happened in 2019 by both the police and fellow classmates. I guess Mr. LALT is young. And he received multiple arrests and at least one conviction for drug-type stuff after entering America without authorization in 2021. In support of his application for asylum and related relief, he testified that he fears returning to El Salvador because of his criminal history and because the Salvadoran police have his picture, name, and address and have registered him as a gang member. But he's not. And IJ found Mr. LALT and his expert credible and granted asylum based on Mr. LALT's being a member of the particular social group, quote, perceived Salvadoran gang members, end quote. Naturally, the BIA reversed. The BIA doesn't believe the particular social group is a group. Yes, imputed particular social groups are a thing, so that's no small holding there on its own by the BIA. Gonna give them that. But in the 2008 decision matter of EAG, the BIA issued a blanket rule apparently that, quote, membership in a criminal gang cannot constitute a particular social group, so the respondent cannot establish particular social group status based on the incorrect perception by others that he is a gang member, end quote. Heads up, based on how the BIA is speaking, I suspect EAG is not good law everywhere. But the BIA does say that it's good law in the Fourth Circuit where this case arises. And actually, yes, the First and the Ninth Circuit explains the BIA. Not good law in those circuits. Chavez v. Garland and Vasquez-Rodriguez v. Garland, respectively, both discussed on the podcast. Unpublished Tenth Circuit decision, too. In this case, the IJ did rely on that First and Ninth Circuit precedent, but the BIA explains that that is wrong because BIA precedent controls unless the relevant circuit says otherwise, and not so in the Fourth. Plus explains the BIA getting into the merits, quote, a proposed group of perceived gang members also lacks social distinction, end quote, as particular social groups require. Not only did Mr. LALT not show this, but, quote, we cannot imagine any situation in which a society would recognize perceived members of a group as a distinct group, end quote. Nor is it particular. Might be impossible to show who is perceived to be in and out of the group, and what the outer limits are, explains the BIA. Quote, the misperception cannot be the defining characteristic of a cognizable particular social group, as the misperception must be based upon some other defining characteristic or characteristics, end quote. So all of this can't be about perception, explains the BIA. Quote, rather, the underlying group is the true particular social group, and where the underlying group as defined is not cognizable, the perceived group is also not cognizable, end quote. So actually, it's not the most non-citizen adverse holding ever, that one. You can have imputed particular social groups, but you're just focusing on what the imputed group would be if not imputed. The actual group, not what is perceived. The BIA explains why all this aligns with Fourth Circuit precedent, namely, its very important Amaya decision from episode 40. Going through all this case law, the BIA then explains why a case-by-case analysis is required, but, quote, it is not inappropriate to rely on established precedent in concluding that certain proposed groups are categorically not cognizable, end quote. The war on asylum continues.
Putting a pin in it then, because, quote, Salvadoran gang members, end quote, is not cognizable to the BIA in the Fourth Circuit, neither is an imputed particular social group connected to it. Quote, the second proposed group, defined as Salvadoran tattooed men, is also not cognizable as it lacks immutability. Tattoos are neither fundamental to a person's identity or conscience, nor beyond one's power to change, end quote. Blazing through arguments, the BIA also holds that, quote, mere opposition to gangs and or gang recruitment generally cannot establish persecution on account of a protected ground, end quote. Rejecting anti-gang political opinion, even though the IJ didn't analyze it, and without much analysis from the BIA either. Going hard on the blanket rules and begging a circuit to say otherwise, the BIA states, quote, a refusal to join a gang, as well as any resulting harm from such a refusal, will not, without more, constitute persecution on account of a political opinion. We reaffirm that conclusion here. Ultimately, the respondent cannot establish eligibility for asylum or withholding based on an actual or imputed anti-gang political opinion, end quote. I seem to recall some First Circuit precedent of late that would find it legit when connected at least to religion. Who knew how much power the BIA could wield? What a time to be alive. So actually, the BIA remanded proceedings instead of ordering Mr. LALT removed, possibly to avoid a direct petition for review to the Fourth Circuit, but who knows? And that is a matter of LALT. And so we come to the end, which really is the beginning. Vargas Rodriguez v. Bondi, published by the Sixth Circuit on September 19th, 2025. Friday of last week that I didn't have time to get to. It's about in absentia motions to reopen. Not gonna lie, pretty sympathetic facts too. After all, although the NTA had all required information, including the first court hearing in it, DHS didn't file that NTA with the court by the date of the hearing. What the heck are non-citizens supposed to do then? And as such, the IJ dismissed the case for DHS's failure to prosecute. DHS issued a new NTA and mailed it to Ms. Vargas Rodriguez's address, the one that they had on file. They also moved to recalendar the first case, which is not the proper thing to do with a dismissed case, but whatever. And yet, the IJ granted the motion and scheduled a hearing for April 2009, 3 years after the first case was dismissed. 3 years. Notice of what the IJ did was mailed to Ms. Vargas Rodriguez at the address in Columbus, Ohio that she had apparently given to DHS 3 years prior. Then the IJ, on its own it appears, changed venue from Arlington, Virginia to Cleveland, Ohio, because that is closer to where the IJ believed Ms. Vargas Rodriguez lived. Then the Cleveland court set it for a hearing. That order, however, was returned to the court as undeliverable. The court rescheduled the hearing and tried to effectuate service, but was not successful. Ms. Vargas Rodriguez did not show up and was ordered removed. The motions to reopen began 4 years later, first based on a lack of notice, with an affidavit from Ms. Vargas Rodriguez and all. An immigration judge denied the motion and the BIA affirmed. Then in 2018, she tried again. BIA denied that too. Third try in 2024, this time based on Pereira and Chavez, even though the NTA was apparently compliant, which is not a great look if true. The BIA affirmed, and that's what we have before the Sixth Circuit. And the Sixth Circuit affirmed the BIA. And actually, it could have been a big deal holding. Quote, this court has not yet ruled in a published decision on whether a petitioner may file multiple motions to reopen based on a lack of notice, end quote. I actually always thought that you could file as many no-notice motions to reopen as you wanted, assuming, of course, that you had the facts. But the Sixth Circuit believes a circuit split exists. The Sixth Circuit did not enter that apparent split, though, so no gong for you. It ruled that the motion lacks merit anyway. Pereira and Ms. Chavez have nothing to do with a compliant NTA motion to reopen, and in any event, Campos Chavez has resolved the deficient NTA issue in the in absentia context, explains the Sixth Circuit. Of course, quote, the fact that the government later provided notice that the time and date of the hearing had changed does not render the NTA defective, end quote. Now true, Ms. Vargas Rodriguez's case was a bit chaotic. Among other things, quote, she argues that because DHS mailed its motion to recalendar to her Ohio address, specifying that her case was closed, she could have reasonably believed that she didn't have a case before the court and had no obligation to update her address, end quote.
Seems pretty convincing to me. The Sixth Circuit was not moved, though. And in any event, it notes that Ms. Vargas-Rodriguez swore in her first motion to reopen affidavit that she didn't receive any notices. Honestly, kind of wish that it was the first motion to reopen on petition for review, but it was never petitioned. The Sixth Circuit distinguished an unpublished Fourth Circuit decision. Then the Sixth Circuit held that the IJ did have jurisdiction over this matter. And I am quite sympathetic to this argument. Ms. Vargas-Rodriguez argued that the IJ could not have reinstated the NTA where proceedings were dismissed originally. DHS had to file a new NTA and start the case all over again, and effectuate service of the NTA again as well. Seems right to me. But the Sixth Circuit relied on the claims processing rule case law and regulations, making clear that all of this isn't really about jurisdiction. Not much more analysis there, though. Honestly, I think a regulatory argument and arguments that DHS and the IJ failed to abide by required BIA precedent might have been better. I don't see how you can do what the IJ did here, but not much more analysis is provided by the Sixth Circuit. Concluding then with sua sponte reopening, the Sixth Circuit held that, likely always and definitely here, it could not review the denial. So Ms. Vargas-Rodriguez remains ordered removed. And that is Vargas-Rodriguez v. Bondi.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.